So this was the irony at the time. That is the reason why this was introduced. The beauty of French system is the scope of resale right, the artistic work included in this, they restricted to painting, sculpture, and the plastic arts, and up to engravings only. And some later they extended to photographs. That is the reason why France has been successful in implementing the resale right, droit de suite they call it. So what is the rationale behind for that? So artworks to be considered distinct from other property because of the contribution they make to the cultural heritage. So that is the reason why every time the price of that work increases, and then the artist has to be given some remuneration. Artist proceeds right is the restitution theory and unjust enrichment. So who are selling this again and again, he is enriching himself unjustly without paying the original author or the creator of the work. So that is the theory behind this, introducing the droit de suite or resale right. One more thing is intrinsic value. The latent value of an artwork at the time of first sale realized through resale. So when art piece is created, now you see all the fresh, latest painted paintings here, created paintings. The value of this painting may be 1.5 lakh now. So obviously there is an intrinsic value in this. Few pieces we just ran around, walked around and saw. When we got attracted to them, and then we know in future they are going to be big piece of arts. The value will increase leaps and bounds, and then obviously that the value, when whatever increase happening, the percentage fixed by the copyright board, that has to come back to the artist. And of course, the copyright law justification is there. It is the an artist has to be encouraged, and adequate financial reward has to be given. But that has to be given to him again and again when it is resold and profits are made. And then based on this concept, the French experts, when the Berne Convention was being revised in 1928 in the Rome revision, they got this introduced, because when this concept was already spread among the European countries, a number of European countries came forward in the Rome Revision Conference. They insisted that this should be a part of the Berne Convention of the literary and artistic works. And it was very successful at the time, and then it was introduced later in the Brussels Revision Conference of 1948. So it took different form. The scope of the droit de suite, the resale right given to the artist, got extended to original works of art and manuscripts as well. Even in Indian law we say manuscripts, not only the work of art, painting, and also the original manuscripts we say. So we have introduced this in our Indian section 53A. And then it is not a minimum right, because when convention talks about all minimum rights, exclusive rights, minimum standards, it is not a minimum standard introduced there, because many countries, their economics are dealing with this intellectual property totally different. They oppose this. That is the reason why the pressure of Europe was so much that they introduced as an optional only. The Article 14 is only optional, because it is not a mandatory provision for all the member countries. And another important thing is there is a material reciprocity. So it is a kind of tit for tat. Now all members don't get the Berne Convention, one of the rights is standard national treatment. So all the countries get a national treatment in implementation. There is no national treatment here. It's a tit for tat theory, material reciprocity. If that is droit de suite in France and India, so Indian goods, artworks are sold in Paris, those are sold in Delhi, they will get the resale right. But not in London other time, of course, because in only 2006, UK introduced this legislation. And then Universal Copyright Convention. This is the convention of the countries, especially led by the US and Russia, who oppose the high standards of minimum rights introduced in the Berne Convention. They did not like, they had a different party and member of countries. Of course, they allowed even when countries also come and join this. India joined here, and then there are Article 1 and 2 talks about adequate, effective protection to the rights of the author to be given, and also national treatment. Because of these two, even though the right to suit or resale right is not mentioned in the Universal Copyright Convention, the implicitness brought the protection of resale right among the countries which signed this convention. And then UNESCO, especially UNESCO administers this convention, unlike Berne Convention administered with WIPO. In 2009, in one of the intergovernmental committee meetings of the UNESCO, all the member countries clearly said that it has to be extended to all artistic works. Member countries have to extend the scope of the resale right to all the artistic works. And then we have a 96 efforts of the European countries, which was materialized in 2001 in the form of EU directives. Intellectual property students, and then though are aware of the copyright issue, there are several EU directives there, and then there is a special EU directive for the resale right. This shows the importance of given to the resale right and the right of artists in the resale by the European countries. And then they have a kind of sliding scale of resale royalties. For each royalty rate they are given by euros, 1 euro to 3,000 is 0%, and the 3,000 to 50,000 4%. It's like the sliding royalty, and then more than 5 million, 5 lakh, whatever you call it, is a 0.25%. The maximum is up to 5% is there. So that's what experts say. This kind of scale resale royalty should not be there. There should be the uniform of 5% for all kind of resale of the artistic works. And then European countries came. Each country created a kind of copyright society, and then there is a European body in which all these copyright societies are members. There are 25 European collecting societies are members, visual artists and creators societies, and then it is catering to the needs of 60,000 creators and painters and other visual artists. So I just given the names of the different countries from Germany, Spain, UK, Denmark, Sweden, and I did visit the Sweden when I was in Stockholm, the office of the post, and interacted with them. And then I felt very sorry for my own country artists and painters and sculptors that we do not have the kind of revenue they are generating. See how the brochures of these copyright societies are really mind-boggling. And then we should, there are 25 societies are members of this European Visual Artists Association. Apart from that, there is a CSAC, I already told you, International Society Council for Society of Authors and Composers. It also monitors the Visual Artists Association, and several artists associations from the Asian countries like Japan and Asia Pacific country, Australia. Australia got a very beautiful law, very generous relatively when you compare it with the UK, which has recently introduced. And then African countries, Latin American countries like Brazil, and across the world, all the members of the CSAC, they monitor it. And then, in fact, United Nations, only one state, California, has this law, not at the federal level. Unfortunate this. That's why the Society of Artists' Rights Society and Vega, another society, they started a movement. Now, recently in 2011, last year, the bill has been introduced in the US Congress about the Equity for the Visual Arts Act of 2011, and it envisages about 7% of resale right. And then, of course, Japan also planning to implement the resale right. And then Venezuela, and especially the CSAC is bringing a lot of pressure on the copyright office there, and to reinstate the autorete, a kind of copyright society which is meant for the visual artists there. And then what are we doing? So what we should do in India to protect the resale right? So who will collect and distribute the share? Obviously the artists and the art dealers, auctioneers, they should come together and then form a copyright society as per the section 33 of the Copyright Act, and also as per the rule 14, which gives what documentation has to be completed for the registration of such society in the Copyright Rule 1958, and then from whom this has to be collected. And then dealers, art galleries, and auction houses can also be part of that. There should be a right to information, very, very important, because whenever the art piece is sold and resold anywhere, so that information has to be given to this copyright society so that they can manage their rights very well, because it is very difficult individual managing its rights. So that is the reason why collective management concept has been introduced in the copyright, and then these are the collective societies, copyright societies, who manage the rights. So how they will collect, but normally by invoices or licenses, and also by individual sales, and then mode of payment by the check, bank transfer, and also when they distribute the amount, they do take some administrative charges, because the society has to be run. There should be a CEO and office, etc. That's what our copyright rule said in this rule 14. Not more than 15%, it says. Internationally, it is from the 15 to 25%. Normally, they start with the 25% in the beginning. Lot of teething troubles and administrative costs. They bring down to 15. But in India, we are starting to end. We say that only not more than 15%. That's what the law says. And then what benefits are regular return surplus. A lot of money you can receive whenever resold, the percentage fixed. And one body can collect and manage your rights and distribute, and then no administrative cost for the individual to manage their rights, because there is already a body to whom you assign your right to manage this. So that is always better. And then identify the auction houses. The societies, they will identify the auction houses, art galleries and dealers who are making resale, and for which the royalty falls due. And they should maintain a very open and transparent method of recording and accounting processes, because what was the first sale and what was the resale, so all the documentation is very, very necessary for the successful and the transparent administration of the copyright collecting societies.